Welcome to Partnerships for Profit, the podcast where we bring you inside the world of joint ventures, strategic partnerships, and powerful collaborations. Each episode, you'll dive into conversations with top entrepreneurs, visionaries, and business leaders, unlocking the secrets to building profitable relationships that drive growth and success. Whether you're looking to expand your network, find new referral partners, or scale your business, you're in the right place. Let's get started.
Welcome to Partnerships for Profit, presented by LeDuc Entertainment. Today, we are joined by John Rizvi, a patent attorney and the founder and CEO of The Patent Professor. John, welcome to the show.
Yeah, it's a pleasure to be here. Thank you.
And can we just start out? Could you tell me a little bit about yourself and a little bit about The Patent Professor?
Yeah, so I'm as you can tell by our trade name, I'm a patent attorney, and I've been practicing 25 years. Actually an adjunct professor of law at Nova Law School, and I became known as the patent professor there. And that's where, when I started thinking about branding my firm, and branding for lawyers is a huge passion of mine, and I've always had an interest in it. It just came naturally to brand it as the patent professor.
Well, and can we talk a little bit more about that? You say that passion for branding sort of came naturally, but when did that come naturally? Was there any kind of a progression to build that passion, or was it just something that was always there?
Yeah, so to me, it just made sense. I mean, when you think of an area of law as a consumer that you need help with, it's really hard to associate last names with practice areas. So the traditional way of branding a law firm was something like Cummings and Willsworth, PA. And it's hard. Like, you have to remember, okay, are they personal injury lawyers? Do they do divorce work? And there's a few large firms that maybe have an incredible budget for marketing that can start branding themselves as specialists in an area. And you think of the name, and then you automatically associate them with aviation law or whatever it is. But it's really hard otherwise to make that association. So at the time when I started branding as the patent professor, very few states, I'm not aware of any, but I'm in my practice is in Florida. Florida did not allow trade names for lawyers. A law firm name had to have the name of a lawyer. That's no longer the case. So at those early days, the patent professor was our slogan instead of the actual trade name. So I think, I definitely was at the cutting edge of trade names for lawyers, but it came naturally. It wasn't something that that took a lot of inspiration or thought. It just made so much common sense that you would, if you wanted to brand yourself as a specialist, that you would do it that way.
Right. Well, and then you see those firms, where they have so many partners in the firm that the name of the firm is 7 last names long. The Broman and Stroman and Lohman and all this.
Exactly.
So could you tell me, I'd like to dive in a little bit more about the patent professor. Can you tell me, who are the people that you help?
Yeah, so we help inventors, individual inventors, small startups. All of that is within our realm. We actually have a lot of corporate clients as well, but our passion is the individual inventor, the person with that new idea that's looking for a way to bring it to market.
And so when these people come to you, what are some of the problems that you're helping them solve? What are some of the pain points that they're experiencing?
So they typically don't know what their first step is. So they have this inspiration for a new idea, and that expression, necessity is the mother of invention, is absolutely true. Like they're facing an obstacle or a problem that they are looking for a solution to, and they typically go and look to buy the solution. So they'll go to physical stores, and then they'll check online, and when they can't come up with something to solve their inconvenience, whatever it is, then they'll go ahead at that point and typically put something together, like MacGyver a solution that helps them. And they're, even at that point, they're often not looking to launch a new product or change an industry. It's just they've got this issue. They don't see a solution out there in the market. So they'll go ahead and come up with something themselves.
Now, and this might seem like a very, very, I guess, basic question, an ignorant question. I don't know, but this is, I guess, for my own understanding. Can you tell me maybe a little bit about what is the difference between a copyright, a trademark, and a patent?
Sure. They're all, different areas of intellectual property. And a lot of times when we're called by clients, they don't really know what doctrine they need to protect their idea or their brand or their creative work. But in short, a patent protects an invention. So if you create something practical that solves a problem, doesn't have to be a physical device. It could be software, but basically something that invents. It's an invention that improves the lives of people. So that would be a patent. Now, when you have this product, you have to call it something, right? You can't. So the brand, the name for the product, is what trademark law protects, and trademark law protects the branding and the consumer goodwill associated with a brand. And now you might ask, so, okay, so what does copyright protect? Copyright is everything else that's creative and that's not necessarily branding or the physical invention. And that could be emails, that can be videos, books. Like, I mean, just a completely separate topic, not related to the product. You write a book, it's not an invention, and a book is not typically something that you would brand. But it is creative work, so you would protect that with a copyright. So books, movies, films, sculptures. Copyrights are quite broad, but I think of them generally as the broad, like, kind of like catch-all for something that's not an invention and it's not branding. So then you want to look to see if it can be protected with a copyright. And we practice at my firm all areas of intellectual property, so patents, trademarks, and copyrights.
Now, you were one of the first board certified IP attorneys in Florida. Is that correct? And can you tell us a little bit about that process and how that happened?
Yeah, so board certification for patent attorneys is something relatively new. So when I first became board certified, gosh, it may have been, I'm guessing 2001, 2002. Florida is one of the first states to have board certification. And the reason for that is that in order to practice as a patent attorney, you already have to take a separate bar exam, the patent bar, that is separate from your whatever state you practice in, because patent law is federal, so you can practice throughout the country. And you have to have typically an engineering degree, a background in a technical engineering or mathematics, chemistry, physics, that type of background, so that you can understand these cutting edge inventions. And if you were registered to practice before the patent office, that was enough for most consumers looking for a lawyer. They would look for a registered patent attorney license before the patent office. Florida wanted an additional certification so that consumers would know that the attorney has had sufficient experience in these matters, not just that they're licensed, but have they actually practiced as a patent attorney. So to be board certified, you had to prove 5 years of experience as a patent attorney. And gosh, it's been so long ago when I don't know what the current requirements are, but I believe at that point you had to show 40 different patent cases that you'd prosecuted from start to finish. So board certification is kind of an added layer of certification that the Florida bar, and now a few other state bars have created.
And what inspired you to pursue intellectual property law? How did that begin?
Yeah, so typically you're as an engineer. I mean, I was always tinkering with things. I mean, taking products apart. My initial first foray into intellectual property was actually goes way back to when I was 12 years old. My goal and sole desire in life was to create a round Rubik's Cube. And I would spend day after day like picking that apart with uh, a screwdriver and taking it apart, trying to see how the thing is made, and then uh, once it's taken apart, trying to figure out how I can make it round. And everything was going well with my designs. I had like page after page of drawings and sketches until one day my mom brought me to the mall. It's this store called KB Toys, and what I saw there on the store shelves like crushed me. It was a round Rubik's cube, and they had a better name than round Rubik's cube. They called it the Impossible.
Mm.
And in my 12-year-old mind, it had, they had stolen my idea, and that's where I would say the first inkling towards and I didn't know it at the time, but that's when I started tinkering with other items and basically would take things apart, figure out how they work. And that led me to become an engineer. And then eventually had my interest in going to law school and becoming a patent attorney and protecting these types of ideas.
That's a really great. I was going to say that's a great origin story of how you found this, and I haven't thought of a KB Toys, and God, I guess those aren't there anymore, huh?
Yeah, I mean, I guess, well, after the pandemic, a lot of people haven't even, the malls are just not the same.
Right.
Like, it's not what they were, 40 years ago.
Well, and the other thing that I wanted to discuss a little bit is you are AV rated, and I was hoping that you could speak a little bit about how that came about and the significance of being AV rated. What does that mean?
Yeah, so the Martindale-Hubbell is a law directory, perhaps one of the oldest law directories in the country, going back to the 1800s, and they kept a directory of lawyers because at one time, for lawyers to try to refer clients, they wanted to find a trusted resource. And Martindale-Hubbell created ratings for lawyers based on peer review. And this was at a time when there was, like well before the internet, where there's no way to check consumer reviews or how any lawyer is doing. You would have an opportunity to see how judges and other lawyers rated your peers' expertise before you referred a client to somebody, because lawyers, we
Right.
can't, we're all specialists. We can't be experts in everything. So this directory provided a way for us to vet the lawyers that we're referring people to, and they have AV, BV, and CV ratings. AV is the highest rating for competence and ethical standards, and they base that upon a certain number of years of experience. Plus, they interview judges and lawyers and get feedback to see how your interactions are with other professionals.
Now, for the past 15 years, you have been a professor at Nova Southeastern University. Can you tell me a little bit about how that experience has influenced your approach to patent law, or how patent law has influenced your approach to being a professor? How have those two things kind of overlapped, I guess, is what I'm asking.
Yeah, so I mean, it's had a huge impact on my practice, because as I teach patent law, and that's an elective for law students. So by the time they take my course, they're third-year law students. Most of them are on their way to graduate, and it's almost like a sense of senioritis all over again, right? Like what happens to high school seniors, and then perhaps college, and the same thing happens in law school. By the time you're in your third year, many of them know their area of practice. A lot of them already have their final employment. Their grades are not going to change that much. So I found myself really taking this complex subject matter of patent law, which is widely regarded as one of the most complex areas of law to practice in, and make it understandable to third-year graduating law students, and make it make sense. And I always looked at trying to avoid legal jargon, so that if these students ran across a patenting issue 5 years, 10 years down the road, they would at least be able to handle the basics and at least diagnose it as a patent, trademark, or copyright issue. As you brought up earlier, a lot of these people get these concepts confused. So that's how I began really taking this complex subject matter, making it easier for law students to understand. And it's so ironic is that in that process, first of all, my practice has grown tremendously because I have you say 15 years, it's actually been 20 years that
Oh,
I've
wow.
been an adjunct professor, but there's 20 years worth of lawyers out there that I have taught intellectual property to that are possible referral sources. And when they come across an issue of intellectual property, I'm one of the first people they think of referring their clients to. But it's helped me in speaking with clients as well, because I take that same simplifying of complex issues into plain English that I've used for law students who are highly sophisticated and understand legal jargon. But there's no such thing, I think, as over clarifying and making things easier to understand. So what works for law students has been a tremendous asset to my practice, because I take these complex areas of law and translate them into practical solutions for people in business, because they're not looking for, they don't want to know the policy behind the law. They don't want to know how it was developed. They have a new idea. They want to know how they can protect it and how they can go forward and make money from their idea. That's really the crux of my practice, is taking the intellectual property laws and applying them for inventors to help them maximize the value of the creations of their mind.
Well, and I'd like to speak, I guess, a little bit more about that because I find that very interesting. What with these inventors that you work with, what are some of the like common challenges? What are some of the most common challenges that you see them facing?
So, I mean, typically one of the earliest obstacles they have is this desire to find out if their idea is worth pursuing, right? So they have this new idea, they believe it's valuable, but they wonder if it's just a personal issue that they're encountering, and is there a large enough market for them? And the biggest mistake I think a lot of inventors make early on is trying to get validation for their idea by discussing it with others. And that's probably the worst thing that they can do, because they're revealing their idea before it's protected. And I do understand the desire to do that. They're like, why patent something if nobody else faces this problem?
Right.
But on the other hand, if you reveal it, somebody else may file the patent before you can. At one point, this was okay, because until 1995, the US was on a first to invent system, which meant that as long as you can prove that you were the first inventor, you had rights, you could assert rights to an idea. All of that changed, sorry, not in 1995, in 2013, all of that changed to a first to file system. So today, it doesn't matter if you invented first. If you don't file that application first, you're out of luck. So it's a kind of a race to the patent office. If you have a new idea, you can't reveal it first. You have to go get it patent pending, file the application, and then you can validate it and see if there's a market and see if others face the problem. But that's one of the first obstacles, is like, do I find out if this is a problem worth solving, or do I file for the patent first? Unfortunately, you can't find out first. You have to file in order to really test the market.
Now, that's really interesting, that change in the system. Was there a particular reason for that change in the system, or how did that change come about?
Yeah, so it is for a lot of inventors, it's a sore topic, especially individual inventors and small businesses, because it's really easy to see how it's an unfair advantage for somebody, like companies like Apple or
Right.
Microsoft or Google, to patent first. Right? They have
Right.
thousands of engineers, they have entire legal departments at the company, that they have patent attorneys that work full time for them. They can go from the idea to patent pending very quickly and win. Uh, so there's a lot of I guess a lot of people upset about that, because when they went from first to invent to first to file, the people who are hurt the most by that is the garage inventor, the
Right.
individual that has a full-time job. They don't have a lawyer on payroll. They don't have a legal staff, and they come up with a new idea. It's a lot harder for them to be first to file than it is when Amazon comes up with an idea. So it is, as to how it came about. There's my cynical views, there's a lot of lobbying by big businesses to switch from a first to invent to a first to file system because they benefit from first to file.
Absolutely. That's pretty wild. I mean, that how that has changed like that, and that's pretty insane, to think about that scaling of that. And I guess I'd like to talk a little bit more about your experiences. And you worked for a pretty historic, pretty renowned IP law firm in New York. Is that correct? And can you tell us a little bit more about that?
Yeah. So when I decided to be a patent attorney, I wanted to work for the law firm of Fish and Neve in New York City. And if you don't know this law firm, you're right. They are the iconic, perhaps most prestigious patent firm in the world. They patented Thomas Edison's light bulb,
Wow.
Alexander Graham Bell's telephone, Henry Ford's inventions relating to the automobile, and the Wright brothers airplane. So this law firm was to patents and inventions. I'll tell you what Muhammad Ali is to boxing. This and so I joined this firm with the hope to work on cutting edge ideas and help find the new Thomas Edisons of today. But what I didn't realize, and I guess in hindsight I should have, is that the Fish and Neve didn't represent inventors anymore. Like most of my days were spent in meetings with corporate lawyers and MBAs at huge multinational corporations. Like their clients were clients like Motorola or Exxon, and I was so far removed from that creative spark of the individual. Like the companies I mentioned, they all started like Jeff Bezos, and Amazon was a concept in his mind. He started in his basement. Apple with Steve Jobs. This is what most of the world changing ideas today. A lot of people don't realize it's not corporations that are making those changes. It's individual inventors that end up exploding and forming these huge corporations as they grow. So that really was my impetus to start my own law firm and represent individual inventors.
Well, and you're not just a patent attorney, you are also a published author. And I was hoping you could speak a little bit to that because I find that utterly fascinating.
Yeah, so I've written, like 4 books. The fourth one is not out yet. 2 of them relate to inventions and patent work. Escaping the Gray is my first book, and it talks about how your comfort zone is actually what's holding a lot of innovators back. I've also written Think and Grow Rich for Inventors, which takes the concepts of Napoleon Hill's classic book and puts them in, specifically in the context of creating a new product. So those are my first 2. I'm also incredibly passionate about branding and marketing for lawyers. So the third book I have is If You Brand It, They Will Come. And that's a guide for law firms to brand themselves in a way that expands their client base and makes them a magnet for the types of clients that they want. And that's exactly what I've done for my firm, The Patent Professor. We've grown from $1 million in annual revenues to 10 million in revenues in a course of 5 years. And I credit a huge part of that to the branding, to branding myself as properly as the Patent Professor, and also marketing. And that's what brings me to the last book is specifically on marketing for digital agencies, and it's actually against most digital agencies because over the course of the 25 years that I've had in my practice, most of the successful marketing that I have found, I've ended up developing myself, using a lot of the work as a patent attorney, the detailed type of analysis and calculating of ROI and spreadsheets. And that's really what should be done if you're marketing. Marketing today is really mathematics. You split test and you try something, and it shouldn't be opinion based at all. It's not like, hey, which version of this graphic looks better? That's archaic. Today, it's so easy to test, and then it doesn't matter what you think looks better as the founder or owner. You want to know what consumers are choosing, and that's what I've used to grow my practice in digital marketing. But the last book is not published yet. Hopefully, very close, perhaps by the end of the year. And it's dirty tricks digital marketing agencies use to rip lawyers off. Because I've learned the hard way, and I've spent, gosh, easily over $1 million in failed marketing. Our marketing budget's $1 million a year, so probably much greater than that. I hate to think about how much money has been wasted, but there's a lot of people marketing for lawyers that have no business doing that. They're not lawyers themselves. They don't understand how unique the marketing has to be. And we're also constrained by what we're permitted to do. I've had digital marketing agencies that I have had to teach the restrictions on advertising to, because they were not aware, for example, that we cannot directly solicit clients the way other businesses can. We can create invitation for clients to reach out to us, but you can't directly email someone. You can't call someone. You can't use bulk emails. There's a lot that can't be done. And if law firms are working with a digital marketing agency that's not familiar with those rules, it's not the digital marketing agency whose license is going to be at risk. It's going to be the lawyer themselves who are responsible for their marketing. So that's a summary of my 4 books. And my I'm also, in addition to the patent professor, my own digital marketing agency is a law firm growth professor, and I focus on digital marketing specifically for lawyers, to help them grow their law practice, the same techniques and strategies that I've used to grow mine.
I was going to say, I can tell that you've got a passion for branding because all of the names of the books are absolutely fantastic. I love all the book titles. They're great.
Thank you. And the same thing there. They're all tested names. So it's not like, hey, which name sounds better? It's testing on social media. It's so easy today. It's so inexpensive to run these tests and figure out which name's gonna be catchier.
And can you tell me, in all of your years of experience as an patent attorney working in IP law, can you tell me, is there a particular story or a particular invention that someone brought you? Is there a particular story that really stands out that you can think of, where maybe you saw a transformation in someone or their idea as a result of working with you?
Oh, gosh,
I know that's a bit of a loaded question.
No, but I mean, there's so many, and I know with the limited time we have left, like which ones to focus on. But I mean, I'd have to say perhaps one of our earlier successes with a patenting case, was a client of ours. His name is Alex Gomez, and he was a medical student who was surprised that in hospital operating rooms, doctors use these instruments with a lens on top, and the lens would get foggy. So to clear that lens, they would either rinse it off underneath the sink or dip it into a flask or something with water, and then put that instrument back inside the patient. This drove Alex crazy. Like, he's a medical student. He knew that this was there's possibly septic. It was introducing bacteria into patients. And the other doctors that he spoke with were kind of looking down. He's a medical student. It's like, what do you know? We're practicing doctors. Nobody really took him seriously. A lot of times when you go in for surgery, the lawyers would create waiver forms of liability for the hospitals and doctors, saying that every operation comes with a risk of infection, and the patient signed that. So there really wasn't that incentive other than to actually save lives, which is what they teach medical students to do. Alex came to my office. He said, John, I've created this surgical lens defogger that is an alternative to doctors just rinsing off the lens and putting it back inside the patient. There's this crude prototype he brought to my office. He put on the corner of my desk, and it literally was created in his garage. And he said it works, it solves problems. But when he brought it to the to the schools and where he was studying and other doctors, they ridiculed him for they called him a dropout, and nobody really took the idea seriously. He asked me to patent it for him, to file this patent and protect it, and we did. And to make a long story short, because we're short of time, but 2 years after we filed for that patent, Alex was able to sell his idea to Medtronic for $100 million. Oh, wow. And today, his surgical lens defogger is the industry standard. It's the standard of care in hospitals and is used in millions of surgeries per year throughout the world. So he's done more. He dropped out, by the way, of medical school to pursue this idea, but he's done more for medical science and patient health by creating his invention than he's ever could have done as a doctor.
Wow. That's absolutely incredible. And John, this has been great. If anybody out there listening has use or has an idea, has an invention that they are looking to patent, could use the help of the patent professor, how do the people find you?
Yeah, so our brand or trade name, of course, is the Patent Professor. So that's our website, thepatentprofessor.com. And as I teach the digital marketing, you want to have a consistent brand everywhere. So on Instagram, Facebook, LinkedIn, Twitter, you name it, just type in the Patent Professor, and it's our registered trademark, and you'll find us.
John, thank you so much for coming on the show. This has been awesome. Thank you so much.
Thank you. It's a pleasure.
And thank you, everyone, for listening. This has been Partnerships for Profit, presented by LeDuc Entertainment. Thanks.
Thanks for joining us on this episode of Partnerships for Profit. We hope you've gained valuable insights on how to form profitable partnerships and take your business to the next level. Be sure to subscribe and leave us a review wherever you listen to podcasts so you never miss an episode. Got a partnership story to share or someone you'd like to see featured on the show? Reach out to us. Until next time, keep building those partnerships for profit.